Hello viewers, today we will be discussing the topic Indian Federalism and the Supreme Court. Now we have already studied that federalism is a system of government where the powers are distributed between the central and the regional governments and each enjoy a certain degree of independence and they coordinately work with each other. A typical federation displays certain important characteristics. First, existence of a written constitution. Second, dual system of government. Third, distribution of powers between the central and the state governments. And finally, the existence of an impartial Supreme Court. Now, this fourth feature is extremely important for today's discussion. Existence of an impartial Supreme Court is the basis of a federal government. Now, why do we need a Supreme Court? We need a Supreme Court in order to resolve conflicts that may arise between the union government and the different state governments or between the different state governments within themselves. Now, we also need to understand that Indian Federation owes its origin to the Government of India Act 1935. Now, the Government of India Act 1935 provided for diarchy and dual system of government. Alongside, it also provided for the existence of a federal court with limited jurisdiction or on center-provincial disputes. Now, when the Constitution was in the process of promulgation, the founding fathers of the Constitution deliberated on the need for the existence of a Supreme Court which would not only be the guardian of the Constitution but also settle disputes in an impartial manner. That is the reason why students, detailed deliberations were held in the Constituent Assembly on the composition of the Supreme Court, the independence of the judiciary as well as the relative jurisdiction. Now, if you try to compare the Indian Supreme Court with other Supreme Courts in other federations, you will find that the Indian Supreme Court enjoys considerable independence and it stands out because the input of the President, the National Executive, the Legislature is quite limited so far as the nomination of the judges of the Supreme Court is concerned. And here we need to understand that maintenance of the independence of the judiciary from executive and legislative control is very important in order to create a successful federal system. Now, the Indian Supreme Court can review not only central statutes but also state statutes or provincial statutes. Now, before we move on to the relationship between Indian federalism and the Supreme Court, it is imperative to understand certain core areas of the Supreme Court. We would focus on the composition of the Supreme Court and how it reflects dimensions of federalism. And secondly, we move on to the Supreme Court competencies and focus on some landmark judgments which have actually influenced Indian federalism. Now, let's start with the composition of the Supreme Court. Article 124 Clause 2 stipulates that the President appoints the judges by warrant but after consultation with such judges of the Supreme Court and of the High Courts in the states as the President may deem for the purpose. This is very interesting, students, because the President is bound to consult the Chief Justice of the Supreme Court and the judges of the High Court while making appointments to the Supreme Court. Now, the next question is, does the Supreme Court represent any regional representation? In other words, do the judges come from the different states and do they have a say in regional issues? Put forth in a different way, we can also say that do the states have a role to play so far as the appointment of the judges are concerned? Directly, no, students. But if you look into the composition of the Supreme Court, you'll find that judges come from the state high courts. Therefore, we need to understand that in terms of regional representation, the Supreme Court draws its composition from justices from state high courts and within that quite substantially from high courts from states which are far removed from the center in a political sense. For instance, in states in India where regional sentiments are very high, for instance, the non-Hindi belt, which has a distinctive linguistic and a regional flavor, you will find that they also send in separate judges to the Supreme Court through the state high courts. Now, we also need to understand that in a recent study of the appointments to the Indian Supreme Court, Justice Chandrachud argues that from a formal point of view, there is no requirement of regional representation in the Supreme Court. In fact, the Constitution of India in Article 124 stipulates that candidate justices must have 5 years of experience as a judge of the State High Court, 10 years of experience as an advocate of a high court, or in the opinion of the president, a distinguished jurist. Now, if you look into the last 6 decades, distinguished jurists or faculty of law schools with experience as lawyers or judges have not been appointed to the Supreme Court. Making the link with the state high courts very important, because most of the judges of the Supreme Court come from the state high courts. However, if you look into the Supreme Court bench, you will find that there is wide geographical representation and diversity. Using the state to which a high court judge was first appointed as a criterion to mark the regional designation, Justice Chandrachud observes that not more than 2 judges of the same high court serve on the Supreme Court at the same time. Now, if you look into the growing size of the Indian Supreme Court from 8 seats in 1950 to 14 seats in 1960 to 18 in 1977 to 26 in 1986 and 31 today, this has facilitated regional representation. Now, we have also seen by the year 2012, nearly all states had former High Court justices represented on the Supreme Court bench. Of all the state high courts, it has been observed that only the Delhi High Court has delegated a disproportionate number of justices to the Supreme Court, reflecting its reputation as one of the most distinguished high courts in the land with a disproportionately high caseload. The 5 southern states of India have always had between 22 to 35% of bench members, whereas the northern states, which include Jammu and Kashmir, but not Bihar, because Bihar is classified as an eastern state, usually held between 30 to 35% of the seats. These reflecting percentages are regionally more balanced and the distribution of seats in the main political institutions. So, we find a wide regional representation in the Supreme Court without the Constitution clearly stating anything about state representation in the Supreme Court. Now, let us come to the second part of our discussion, that is Supreme Court competencies, because in a federal system, it is very important to understand the jurisdiction of the Supreme Court on federal issues. Now, on federal issues, the Supreme Court has the competence to decide legal disputes between a state or states or between the union and the states. Article 131 of the Indian Constitution stipulates that questions of legal issues are not political disputes, which normally should be addressed to intergovernmental means. So, legal disputes should be taken and not political disputes to the Supreme Court. Disputes of the matter must be brought to the court by the Government of India or the state government acting through the ministers. Article 262, however, provides that inter-water river disputes is beyond the purview of the Supreme Court. Such disputes are to be settled by separate tribunals, and here it should be mentioned that the role of the court is quite limited to enforcement of a river sharing award enacted under the Interstate River Water Disputes Act of 1956. So, one thing is clear, that the Supreme Court has limited jurisdiction so far as interstate river water sharing awards are concerned. But we need to understand that this jurisdiction of Supreme Court competencies has definitely altered center-state relations in India. Over time, the Supreme Court has become more appreciative of state rights, state autonomy, a feature which many observers see as compliant with the strong position of the states in both economics and politics since the 1990s. In political terms, we already know that India represents a pluralized party system in which state-based parties were needed to prop up a central parliamentary majority since the days of coalition governments. This created conditions in which the central government became more accepting of political state autonomy. Simultaneously, we also need to focus on the fact that the Indian economy has become less centralized and more encouraging to state rights so far as economic policy are concerned. Moreover, liberalization has also enabled state-based private investment to stimulate the economies of the state. Now, we also need to understand that how far has Supreme Court jurisprudence influenced federal issues. Now, please note that a more favorable reading of state rights is not confined to all areas. We would now focus on some areas of Indian federal system and the Supreme Court competencies in those areas. One very specific area and which is very popular is the precedence rule, or what we know as Article 356, imposition of state emergency in the state. Now, we have observed that over time the number of imposition of emergencies in states have come down considerably. You have to give credit to the Indian Supreme Court in policing the union and bringing down the rate of imposition of state emergencies. But this was not the case. If you just look into how Supreme Court had tackled cases pertaining to state emergencies, you will find that there has been a change in stance of the Supreme Court since 1977 to what we see today. Let us take upon one such very important case, which is the case of the state of Rajasthan versus Union of India, 1977. What happened in this case? When the Janata Party came to power in 1977, it issued a directive or a letter to Congress-ruled state governments to resign or face the risk of proclamation of emergency under 356. The states challenged this directive of the Janata Party-led union government in the Supreme Court. The matter was decided by the 7-judge bench. The case was State of Rajasthan versus Union of India, 1977, and here I quote what the Supreme Court said about imposition of state emergency. The court cannot in these circumstances go into the question of correctness or adequacy of the facts and circumstances on which the satisfaction of the central government is based. That would be a dangerous exercise for the court, both because it is not a fit instrument for determining a question of this kind and also because the court would thereby assume the function of the central government and in doing so enter the political thicket which it might avoid if it is to retain its legitimacy with the people. Yet, in another case, A.K. Roy versus Union of India 1982, the Supreme Court ruled that the constitutional position under which the Rajasthan case was decided cannot any longer hold good. So, we need to understand two things in these cases. The first case did not try to alter the status quo of the central government. The second case, however, went a little further and said that what was said in the state of Rajasthan case does not hold true today, and we need to come out of this stigma of the central government imposing state emergencies quite often. Now, a more definitive judicial stamp came on the imposition of state emergencies in the S.R. Bommai versus Union of India 1994 case, and which is considered to be an important landmark so far as state emergency imposition is concerned. Here the Supreme Court clearly stated that the exercise of power by the President under Article 356 Clause 1 to issue proclamation is subject to judicial review, at least to the extent of examining whether the conditions precedent to the issuance of the proclamation have been satisfied or not. So, this was a landmark judgment where the Supreme Court came down heavily and very strictly pronounced its judgment that the centre cannot, through its whims and fancies, keep on imposing precedence rule in the states and thereby make the state governments rubber stamps. The Supreme Court also issued a number of directives in the S.R. Bommai case under which presidential rule can be imposed in states or not. Now, since this judgment was delivered, the frequency of the presidential takeover of the states have markedly decreased. Furthermore, we have also seen that the Supreme Court has upheld its activist stance in cases which have followed hence. For instance, in another very famous case, for example, Rameshwar Prasad versus Union of India, the Supreme Court invalidated the presidential dissolution of the Bihar Legislative Assembly a few months after the elections in 2005 on the advice of the governor who anticipated the formation of a non-Congress government. Even if you look into very recent cases which emerged in a context in which the BJP had recaptured an absolute parliamentary majority in the 2014 elections, the Supreme Court held on to its previous position in defense of the states. A crisis emerged in Uttarakhand in 2016 when 9 Congress party leaders rebelled against Congress Chief Minister Rawat and joined the opposition camp. The central government imposed precedence rule in Uttarakhand a day before the floor test was to take place. When the matter reached the Uttarakhand High Court, it squashed the presidential rule. Subsequently, the matter went to the Supreme Court. The Supreme Court stayed the Uttarakhand High Court's decision and ordered a floor test, disqualifying the 9 members who had defected from the Congress party. The Uttarakhand government won a vote of confidence and therefore the government was reinstated. Therefore, we find a positive influence of the Supreme Court on state autonomy and state rights. Now, let us come to another very important area of discussion, Supreme Court and amendment procedure, because amendment is an important power of the union government and amendment makes the union government very powerful in curtailing the constitutional provisions by way of modifying, amending or rejecting a particular provision. Now, in relation to amendment procedure, Supreme Court jurisprudence has become similarly receptive to the rights of the states. The Supreme Court in the very famous Keshavanda Bharati versus State of Kerala 1973 argued that the Parliament has the power to amend any part of the Constitution including fundamental rights. However, the judgment carried a caveat, and which is very interesting, that amendment is not an absolute power of the Union Parliament and it does not include the basic structure of the Constitution, which means that the Parliament has a power to amend the Constitution, but it cannot amend or alter the basic structure of the Constitution. And the Supreme Court in a number of guidelines laid down what constituted basic structure of the Constitution. Post Keshavanda Bharati, in several other Supreme Court rulings like the Minerva Mills versus Union of India, S.R. Bommai versus Union of India, I.R. Kolo versus State of Tamil Nadu, the Supreme Court has over time come out with various other dimensions and interpretations of the basic structure doctrine. And please note, students, within this basic structure doctrine is included judicial review, federalism, and such other areas. For example, secularism is also part of the basic structure doctrine. Now, what is important to note here is that the Union Parliament has the power to amend the Constitution but cannot alter the basic structure. Now, if federalism is a part of the basic structure as provided by the Supreme Court in a number of rulings, the basic structure of federalism can also not be altered by the union government through the power of amendment. But there have been a lot of controversies on this because 368 clause 4 and 5 provides that no court in the country can question any amendment made by the Parliament by use of Article 368 of the Constitution. Thus, there is a lot of controversy on the issue of the power of the Parliament to amend the Constitution. Nevertheless, another important area that we need to understand is judicial review. What is judicial review? Judicial review empowers the Supreme Court to declare a law passed by the Union Parliament or the state legislatures as null and void if they contravene or conflict any provisions of the Constitution. Now, the Supreme Court is the guardian of the Constitution and any law, if it violates the provisions of the Constitution, can be declared null and void by the Supreme Court. Now, this was also an area of controversy because laws made by the Union government can be declared null and void by the Supreme Court if the Supreme Court observes that a particular provision of the Constitution has been violated by that particular Union law. But there is also a caveat here that this is not just for Union laws also, this works equally for state-made laws also, that if a law made by the state legislature violates a provision of the Constitution, the Supreme Court can come forward and designate that law as null and void. Now let us come to jurisdictional issues and whether the Supreme Court has taken the side of the union government or the states. And we have some very important observations coming from the Supreme Court to show that Supreme Court has taken a very balanced view when it comes to resolution of conflicts between the union and the states. Let us come to one such very important case, and that is the State of West Bengal versus Union of India 1963. In this particular case, the State of West Bengal challenged the constitutionality of a union law which is called the Coal Bearing Areas Acquisition and Development Act 1957, enacted by the Union Parliament, and this act provided for the power to control the coal bearing areas. Now the conflict was on the fact that the land where the coal bearing areas were there fell within the State of West Bengal. So, who had power to control the coal bearing areas? The Supreme Court ruled that the state right in the matter was subject to union right and national interest under the Constitution. So, here the Supreme Court went in favor of the union government. Another important area was related to the Parliament's power to levy wealth tax on agricultural land. And please remember students, agricultural land is a state subject. In the Union of India versus H. N. Dhillon 1972, the Supreme Court affirmed that Parliament's power in this matter is a residuary subject. However, in another subsequent case, which is the International Tourism Corporation versus State of Haryana 1981, the Supreme Court decided not to lean too heavily on the residuary power of the Parliament under entry 97 of the Union list and thought it desirable to give a broad and plentiful interpretation to the entries in the state list so as not to whittle down the power of the state to the detriment of the federal principle. So, in this particular case, the Supreme Court aligned itself with the state interest. In a more recent case, State of West Bengal versus Kesharam Industries Limited, the Supreme Court examined the constitutional allocation of legislative and taxation powers between the centre and the states at great length. The matter related to coal, tea, brickfield and minor minerals in which entries in the state list are subject to Union's power of regulation and development in the interest of the nation and the public. Some important point of interpretation came up from this case and which is worth noting. The Supreme Court held that the various entries in the three lists, that is the Union, State and Concurrent list, which specifies the Union, State and Concurrent jurisdiction are not powers of legislation but fields of legislation, and taxation is considered to be a distinct field and should be left out from the three lists. The Union's power to regulate and control does not result in depriving the states of their power to levy tax or a fee with their legislative competence without trenching upon the field of regulation and control. Every effort should be made as far as possible to reconcile the seeming conflict between the provisions of the state legislation and the union legislation. So, here the Supreme Court offered a more balanced interpretation of the union rights and the state rights. But while so far we found that the Supreme Court taking a balanced view and a little tilted towards the state, there are two areas where the Supreme Court has strictly maintained a close liaison with the union government, liaison in the sense that it has provided favorable decision so far as the centre's ruling is concerned. What are these two areas? Article 3 and treaty making powers of the union government. Now, with the rising role of the states in foreign policies and their increasing relevance in political communities in a pluralized multi-party system in India, since the 1990s, the Supreme Court may be expected to find ways in which a stronger input of the states in both processes could be found. Yet, in one of the rulings, the Supreme Court has said that if a treaty, agreement or convention with a foreign state deals with a subject within the competence of the state legislature, the Union Parliament alone has power, notwithstanding Article 246 Clause 3, the power to make laws or implement the treaty, agreement and convention. Thereby, this power is conferred upon the Parliament, which it may not otherwise possess. Therefore, it clearly provided that so far as treaty making powers is concerned, even though a state may be connected or concerned or related, ultimate power lies with the Union Parliament as far as the Constitution is concerned and not with the states. There's another area so far as Article 3 is concerned. Article 3 gives the Union Parliament the right to increase the size of the state boundaries, decrease or alter state internal boundaries of the state. So far as state's consent is concerned, that is not mandatory. The state can be consulted, but their consent is not mandatory. So a number of cases came up to the Supreme Court, where the Supreme Court provided a meaningful interpretation of the power of the Union government so far as Article 3 and state boundaries are concerned. I would just focus on one or two such cases. The first case is Babulal Parathe versus State of Bombay 1960, which was regarding the reorganization of Bombay into Maharashtra and Gujarat. In this case, the Supreme Court was asked to address the validity of the Parliament which unilaterally amended a previously sanctioned bill by the Bombay State Assembly to split the state into three parts: Maharashtra, Gujarat and the Union Territory of Bombay. Instead, what the Union Parliament did, was it revokes its earlier proposal and decided to include Bombay within the state of Maharashtra. In justifying this decision, the Supreme Court argued that the states have no rights under the Indian Constitution and the Parliament's power to right-size territories was absolute. The Supreme Court maintained this particular line of argument by tilting towards the Indian government in a number of other cases, and this related to the Uttar Pradesh Reorganization Act of 2000 concerning the city of Haridwar. According to Article 3, the President must refer the bill to create a new state to the parent legislature to elicitate their views. Now, in this case, the issue pertained to the creation of a new state of Uttaranchal, including Haridwar city, but not the entire district of Haridwar. Now, after the state legislature approved the bill that the city of Haridwar will go to Uttaranchal, what happened was that the Parliament included the entire Haridwar district within this new reorganization bill. The petitioner sought a referral of the amended bill to the state legislature because he said that his consent was not taken about the entire district of Haridwar and that they had given consent only for the city of Haridwar. The Supreme Court dismissed this view and argued that substantive compliance with the proviso was sufficient, and even in a case where substantive amendment is carried out, the amended parliamentary statute need not be referred to the state legislature again for obtaining fresh views. So, referring once is good enough. Now, let us try to understand what we have learned so far from Supreme Court competencies, division of powers, interpretation of cases. Now, all these cases that we have studied so far demonstrate that the Supreme Court has become an efficient guardian of federalism through its jurisprudence on precedence rule and the constitutional entrenchment of federalism as a part of the basic structure. Here, the Supreme Court has played a positive role in strengthening Indian federalism. However, we should also note that the same does not appear to hold true for cases which deal with center-state conflicts and legislative competencies. One may assume that the political climate, which had become more favorable to state rights since the 1990s, enabled the Supreme Court to adopt more favorable state-oriented positions in recent rulings. In contrast, the Supreme Court had held a restrictive reading of the powers of the states, and we have just studied about the treaty making power and Article 3, where the Supreme Court has clamped down the powers of the states. Thus, we can conclude with three important areas. Number one, Supreme Court has clearly established itself as an effective guardian of the Indian Constitution as well as Indian federal system. Second, federalism has been entrenched in the basic structure doctrine and federal provisions cannot be altered. Finally, the Supreme Court has taken a balanced view of the centre and states' legislative competencies. Thank you.